Yes.
May I have my lord's kind leave to mention the Rose Valley matter, my lord? It was made returnable tomorrow by your lordship by the last order. There are certain urgent directions that the ADC would be seeking from your lordship.
Tomorrow we will sit.
Deeply obliged.
Your Lordship, may I be allowed to mention an application for anticipatory bail? For relaxation of anticipatory bail, it is very urgent as the petitioners are since order dated 13 September 2023 are visiting the concerned police station every week, and it has been around more than 1.5 years. Please, Your Lordship.
The cancellation of anticipatory.
Admission of grateful Lordship.
May I solicit your lordship's kind leave for enlistment of this matter, my lord? It's a circuit bench matter. NDPS, my lord, co-accused statement, my lord.
We will hear on Monday.
But I'm being hounded by police, my lord. That's the urgency. My
Hounded by
anticipables
police?
to dismissed by the concerned
May
court.
be hounded by police. We will hear on.
I will be requesting for an interim order till Monday in that case.
We will not be giving you anything.
So I will file it in
We
circuit,
may
my
be
lord.
inclined to dismiss your
No,
application.
my lord, I will file it in circuit then.
Application for relaxation of bail.
Correction.
Well, may I have your lordship leave to mention this matter for correction, my lord? I had mentioned this once earlier, and your lordship had granted bail, but my lord, but since the court's name is wrong, my lord, they are not releasing one. Grateful, my lord.
Call the list.
Item 1.
কোথায় কে আছে? ঠিক আছে পেপার right. Where is the appellant? Aparna Ghosh. Where is the appellant? And who is for state in this matter? There is a letter written that the appeal is not being heard out. We want this matter to be sent to Circuit Bench, Jalpaiguri. The Honorable Chief Justice has assigned this matter before this bench for expeditious disposal.
Upon an amicus curiae.
Let us wait for another day. We keep it on day after tomorrow. Appellant is
Day after tomorrow, Miss Gore will be.
We are not fixing it for hearing now. Like, let the appellant first be kind enough to appear. Appellant is unrepresented. Appellant is unrepresented. Learned public prosecutor appears for the state. Appellant's counsel had prayed for expeditious hearing. Had prayed for transfer of the matter to the circuit bench at Jalpaiguri for expeditious hearing. Honorable the Chief Justice was pleased to assign the matter before this bench. When the matter is listed, when the matter is listed today, appellant is unrepresented. To enable the another chance is given to the appellant's lawyer to appear. Matter is kept day after tomorrow. Department shall communicate this order to the appellant concerned in the correctional home.
একবার রেকর্ড দাও তাহলে আমি কারেকশন হোমটা বলে দিতে পারি স্যার Item 2. What a position.
My lord, in this matter, anticipatory bail was rejected on 11th December 2024. And lordship, observation is that, my lord, kindly transferred this matter before the cyber crime cell. And my lord, it was transferred on 3rd January 2025. But my lord, we not get report. It is not ready because, my lord, there is
When do you want to file the report?
tomorrow.
Tomorrow, not today. Next matter. Yes.
Item 3 and 4.
Is Mr. Mohapatra, yesterday you made your submissions.
Well, may I add?
You can always add how much you will add. You have added entire afternoon yesterday.
No,
You have
Marat-
put in your written arguments. What more
Marat-
do you want to
well,
add?
that's not written. Only how to discard PW1. That I have tried my
You
level.
have, sir. How much? You have got your point. Would you be saying anything more than this?
Yes, man.
Anything more?
On point of law, Marat, only
Yes.
this much. Marat, yesterday, Marat, I was making submission that there is no charge under section 34, 120B or 149. Marat, there is a reason, Marat. Marat, yesterday I read whole paper book once again. Marat, because Marat, there was no premeditation. Marat, they came for killing the deceased father, not this person. So, Malat 34, Malat regarding that, Malat 34, 120B or 149, Malat, it's their choice. Malat they decided that this was just a, Malat, I'll say scuffle or something like that. Prosecution has portrayed this. Malat, this is one. Malat, no common intention, common object, obviously. Malat, this is one. Malat, your lordship would also see, Malat, there is no charge under section 25 Arms Act. I made this submission yesterday also. Malat, sharp cutting object falls within the ambit of section 25 of the Arms Act. This arms has not been recovered from me. This arms has been recovered from Horen and Shamapada. Your lordship has already seen. Malat, if the arms has not been recovered from me, how I am being implicated? The supporting document is that my confessional statement.
This is repetition.
This is
You have made your submission on the impact of absence of charge under Arms Act. We have understood your submission. Now you proceed to any other point.
This confessional statement of mine, what your lordship directed me to go through, I have gone through. This perhaps doesn't help prosecution because in that thing only what I have stated is that I was present that much and the relevant portion would be আমি যখন নেশাগ্রস্ত অবস্থায়
You had not, you are again the same thing. The statement does not show you shared common intention or you assaulted. Very good. Very good.
The Nishikant Jha case, in that case, knife was recovered from that appellant. On the point of law, in fact, in Nishikant Jha, your lordship would see.
Or Mr. Mohapatra, you are repeating. You have made your submissions. Now you please sit down.
My lord, my humble submission is that, my lord, benefit of doubt, my lord, with Horen.
What benefit of doubt to Horen? Why benefit of doubt to Horen?
Contention, my lord, the PW1 and PW6. Position of PW1 and PW6, my lord.
Bikash takes the name of Horen. PW1 identifies Horen as one of the persons present. What more? Horen admits recovery of the knife pursuant to his leading statement.
From Horen X.
Please, sir, you made your submissions. Now you rest for some time. Okay. Let others also have their say. The knife recovered from Horen has blood. human blood. What more? We are more from your client. We are more concerned. We'll call upon Mr. Public Prosecutor and with regard to Sushanto. Bikash has not withdrawn the so-called exculpatory statement. Sushanto retracted that.
Co-accused statement, my lord, on the basis of co-accused statement, it is my lord permissible.
Correct, not permissible. Had it not been PW1 identified you, PW1 identified you, your presence, then we consider Sushant. Yes,
But so far as Susanto is concerned, my lord has seen the FIR. The FIR maker,
FIR is very doubtful.
FIR maker is an eyewitness. FIR maker, well, very doubtful, but FIR maker.
There are two, in fact, Mr. Mohapatra has extensively argued primarily on the FIR. He says that the genesis of the incident in the FIR and in the court are at variance to one another.
I'm not on that.
22 people came, charge sheeted only 4. And in the deposition, the PW1, the maker of the FIR, does not take the name of these 22 persons. In fact, going through the records, we find when the charge sheet was filed, an application for further investigation was made by the de facto complainant PW1. Judge says, we are not allowing further investigation. If evidence comes, we may issue process under. Now that becomes final. When it comes to court, PW1 does not utter anything about those other 22 persons.
Different aspects with regard to the Your Lordship, whatever is the FIR story has gone a sea change during the course of the trial. If I may say so. I'm not on that. The FIR is a very lengthy FIR. The FIR has been as scribed as per the dictation of PW1. PW1 has named so many persons and forgot the name of Susanto.
That is the biggest problem.
Now, in PW1,
There, on the first day, our impression was that if FIR is so extensive and Sushanto's name does not appear during trial, only PW1, and that too just taking name of Sushanto, bold allegation that they had assaulted, becomes an embellishment. PW6 is doubtful whether she had seen the incident or after the incident she had come to the spot. It is only PW6 who says that Sushanto assaulted specifically. The thing which weighed with is the statement of Sushanto. PW6 is the wife of the deceased.
she was not there.
She claims she is there. Mother-in-law says she came later.
Mother-in-law says she came later. PW6 also says I heard the names from my father-in-law.
Not only that, PW6 also says I did not know the names of the.
Yes, I heard it from my father-in-law. The most important is PW14. He claims about one Susanto, but during the identification also might be.
We have seen.
Now
No, PW14 is a reported witness.
Now, if you also see the statement of Susanto, whether he retracts or doesn't retract, it has nothing to got to do with the incident. Your Lordship, see,
We have seen.
played away. They were looking.
That is his statement. Our contention was, now if we accept Sushanto's statement, then Bikash's statement, if we accept, we should give acquittal to Bikash. You see Bikash's statement.
But because goes to the house. Here what
Yes,
happens?
Sushanto also goes to the house.
Susanto goes to the house. The man is called. There is no answer. Now Susanto is pushed.
He falls down, he runs away.
And flees away. He was not privy to any of the incident. The tiles being broken, the
Now, what does
target
Vikas say?
fleeing away.
What does Vikas say? I was in the house of Horen. We were drinking. We went to the house
Said,
of.
I didn't know that he had the.
No, not only that, he does not admit to calling PW2. Does not admit calling PW2. He says, Shamapodo called. Shamapodo called, and then he asked for water. Sun came out, and Shamapodo attacked. Now, if we believe Vikash's version, then though he admits his position, statement, his place, his presence, he does not admit to be the assailant.
No.
From his statement, he also creates an impression that he was unaware of the fact that one of his compatriot was carrying a weapon and had intention to use the weapon. So he should also be acquitted.
Your Lordship will add that part of the statement that he was unaware of the acts being carried with a pinch of salt. Your Lordship.
No, we
acts being carried without the knowledge of the court, it's impossible. It's impossible.
No, we understand the thing.
It is not a small dagger or a firearm.
Malat,
Now,
may I say?
now
Mr. Mahapatra.
my lord, my lord, PW1, I won't address your lordship on this point. My lord, forgets everything. Forgets everything. My lord, just considers it.
No, we have.
Say, as per the Supreme Court judgment, your lordship can rely on this judgment and pass an order of whether acquittal or conviction, whatever it is.
Yes, that is what we are saying, that we have to whether we rely on PW1 or not.
Yes.
Now, PW1's presence in the house is not disputed.
Nobody can deny.
Right. But the manner and circumstances in which the incident happens is not consistent. 22 people come, and one Bhoirab and Vikash assault. In the court, 4 people.
Horen, Vikas, Bikram, Vikas, Mrityunjay, Samakti, Susanto, Samusarta. There are Horen, Susanto, Vikas are present in court. Incident took place 2 hours, 10 months back. Horen, Vikas and other persons whom I could not identify. So
In the FIR, it is Bhoirab who asks for water. In court, it is Vikash who asks for water. Now that I would say, admission of Vikash in the statement erases this conflict, because himself admits that I asked for water. The second thing is, Horen sent Vikash and others, right? In the FIR, it is someone said, I am Vikash. I am Vikash. Horen sent us. There is some discussion. That is the FIR. And PW2 says, আমি বিকাশ এসেছি, হরেন মুর্মু আমাকে পাঠিয়েছে, একটা আলোচনা আছে, তুমি দরজাটা খোলো. So we find the corroboration of the FIR in PW2's version. Right. And this evidence, as you rightly say, persuade us not to accept the exculpatory statement of Vikash that it was not, he was not the person who had asked PW2 to open the door.
Yeah.
So one aspect of Vikash's role in the incident sought to be taken away is that appears to come out both in FIR and PW2's version and PW1's corroboration. Then comes Bikash's role in asking for water. Why did he ask for water? In order to lure one of the persons to come out of the house. That person came out of the house. Then he was assaulted. Fact that he is assaulted is admitted by Bikash. Who assaulted? Bhairav and Bikash in FIR, all in PW1's version. PW2 is not a witness to the assault.
PW14 in this case will be very crucial. My lord,
PW14 is a reported witness and not a registered witness.
my lord, maybe, my lord, but PW4 is specific about Vikas. He doesn't know the identity. It is admitted he doesn't know the identity of Susanto. Maybe Susanto, maybe Susanto. This Susanto may be Bhairav.
Sir,
And my lord,
PW14 sir, here second.
Because there is consistency. Shantu is concerned, we can give the benefit of doubt.
Yes.
Now let's take the appellants. Appellants have assailed judgment and order. ওটাই না আগের যেটা ডিকটেশনটা দিয়েছিলাম ওটাই আমি Yes, Mr. Mopatru, you want anything to be added?
My lord,
You rose up actually about because
the only thing is that
our clear understanding is we will accept the exculpatory statement when the exculpatory statement finds corroboration from other materials. But if the exculpatory statement is rendered improbable or inconsistent with other legal admissible evidence, then the exculpatory statement is to be discarded. That is the ratio in charge. And I will follow that. So far as what is corroborative, I will accept. Whatever is not corroborative. Susanto, we will be giving the benefit of the doubt. Let us give Susanto the benefit.
The only thing is that, my lord, if I am not wrong, my lord, your lordship's impression is that I was present. But whether my lord,
impression ki it's your client's
my lord,
statement, sir.
yes, my lord, if
What are you saying?
my lord, mere presence and
correct presence and
And
trying to
overt.
shirk responsibility.
my lord,
Both of calling. See, three things you do. Calling, asking for water. Now what? Why asking for water? See the narration of the prosecution case. To enable the person to come out of the house. You were a band of individuals who, as per the evidence of PW6, you do not enter the house
No.
of persons. There is a discipline in your violence. You are an organized violent community. So that's the prosecution case. We don't believe, we believe whatever. Because of that, you want him to come out. You never said, I was thirsty and I asked for water. I asked for water. And I started drinking water. I didn't know he was carrying an axe and he hit it. Right? My thing is carrying an axe, hit it in light of PW1 and the FIR. falsus in uno may not be falsus in
No,
omnibus.
in Indian
But
jurisprudence.
what the deviations in the FIR and so do not go to the root of the prosecution case with regard to the assault and murder. It creates a doubt with regard to the participation of other who were exonerated by the police and not brought on record by the court because of absence of evidence. Their exoneration does not affect the kernel of a prosecution case, where one of the accused is not only sharing common intention by being a passive member without overt act, but a member with overt act. This is a member with overt acts. Calling is an overt act. Asking for water is an overt act. So we'll hold it in this way.
Resolution.
Judgment order dated 29/9/2018 and ওটা তো করাই আছে আমার। সরি, এই ড্রাফটটা করা আছে। ডিকটেশন দিয়ে দিয়েছে। রাইট। মিস্টার মহাপাত্র, ইনিশিয়াল পাত্র, Mr. Mohapatra contends the prosecution case is wholly unreliable, unreliable. Manner and circumstances in which Shamol was murdered.
Shamol.
Manner and circumstances in the manner and circumstances in which Shamol was murdered as per FIR. As per FIR, the manner in which Shamol was murdered is at variance with the prosecution case narrated by the witnesses, including the de facto complainant PW1. In the FIR, PW1 claimed 22 persons had come to their house, they were variously armed. They started entering, they were variously armed. One Bhoirab had asked for water. They started breaking the tile roof, semicolon. Her son and daughter opened the door. Bhoirab asked for water. When his water and she provided water, then Bhoirab and Bikash then the accused shouted, then all the accused shouted, they would kill her husband, and when they could not find her husband, they asserted they will kill Shamol. Bhoirab and thereupon Bhoirab and Bikash struck Shamol with axe, resulting in his death. In court, PW1 stated named only 4 persons, namely so and so, Horen, Bikash, now in court 1, 2, 3, 4, 5, 6. In court, PW1 named 7 persons, namely Horen, namely the appellants and Shamapodo, Sampoti, Shamapodo, Sampoti Murmu, Bikash Tudu, and Mrityunjoy Ghoshal. She stated Bikash had asked for water, and thereafter Bikash had asked for water, and when Shamol gave water, they searched for her husband and when they were unable to trace him, they hit Shamol with a kural, with an axe, resulting in his death. Full stop. Resulting in his death. The variation in the prosecution case is so palpable that it is rendered inherently improbable. FIR, registration of the FIR is also shrouded in mystery. PW1 and the scribe PW5, shrouded in mystery. PW1 and the scribe PW5 stated that they went to the police station to register FIR, whereas PW16 claimed that the written complaint was received at the spot by the IC and forwarded to the police station. PW5 is a political leader and Now, this gives impression that the original FIR was substituted and a subsequent FIR was prepared at behest of PW5, a political leader. Full stop. He also contends PW2 and 6 are not eyewitnesses, to the incident. Statement: no arms was recovered from Bikash Murmu. He has not been charged with the offense under section. He has not been charged. No charge under section under the Arms Act had also been framed. Good stuff. He prays for exculpatory statement. He made an exculpatory statement before magistrate, explaining away the circumstances in which appellant was murdered. Accordingly, he prays for acquittal. Mr. Bhattacharya for Horen and Sushant contend none of the appellants were present at the spot. Complicity of Horen is based on statement of co-accused, that is Bikash Murmu, and inadmissible in evidence, which is inadmissible in evidence. Full stop. Recovery of, was it X?
X. From Horen X.
Recovery of X from the
X from Horen from Shamapodo Katari.
Recovery of X from Horen is doubtful. Doubtful. FSL report does not show presence of blood on the seized article. Article. In respect of Sushant, he contends appellant was not present, appellant is not named in the first information report. PW1 disclosed his presence for the first time in court. PW6 PW6 is not an eyewitness. She also disclosed the role of Sushanto in court for the first time. Sushanto for the first time. Exculpatory statement of Sushanto shows statement of Sushanto before magistrate. Sushanto retracted his statement. Even if the retraction is ignored, the statement, his Sushanto's statement before magistrate is exculpatory and shows that he was not present at the time of occurrence, at the time of attack. He prays for acquittal. Mr. Learned Public Prosecutor with Ms. Gore submit incident occurred at the at PW1's residence. Incident occurred at the dead of night at PW1's residence. She is the mother. She is the mother of Shamul and eyewitness to the incident. Though their role of the appellants are clearly depicted in the first information report as well as in court, by prosecution witnesses. Exculpatory statement of Bikash admits his presence at the place of occurrence, as well as the fact that he had asked for water to lure Shamul out of the house. Asked for water, full stop. This lured Shamul out of the house when he was brutally assaulted by Bikash and others. Full stop. Presence of Horen. Horen is the mastermind of the crime. His presence is noted by PW1. His presence is noted by PW1. Is noted in the first information report as well as by PW1. Full stop. On his leading statement, weapon of offense, that is axe, was recovered. Recovery was after a considerable period. About a month, na?
Almost. Almost, and not only that, though I am not appearing for them, the witness to that seizure are wife and daughter of the co-appellants.
So what?
They specifically stated they went to police station.
They did not support the case. Mr. Bhattacharya, the independent witnesses have not supported the case of recovery. Good stuff. Acha. When was the incident?
Incident was a 26th May at 2:10 a.m.
Due to lapse of time, blood had degenerated. Full stop. Blood had degenerated, and hence the FSL report. Blood had degenerated and could not be detected in the FSL report. Full stop. In the FSL report. Accordingly, he prayed for dismissal of the appeals. Full stop. PW1 is the complainant, is the de facto complainant, and the first informant. Is the eyewitness and first informant. Learned counsels for appellants have seriously assailed seriously assailed the registration of the first seriously assailed the registration of the first information report itself. They contend PW1 stated that she had gone to the police station and registered the first information report, which was scribed by PW5. PW5 also stated he scribed the complaint at police station. But PW16 as well as endorsement in the first information report shows it was received at the village and forwarded to the duty officer to the duty officer for registering specific case. Full stop. PW1 is a rustic lady. It is a rustic lady. She had lost her son, and to a brutal attack by a group of Maoists, by a Maoist group. Full stop. She is unclear. She is unclear with regard to the manner and circumstance. She could not, in court, she could not clearly state where she had handed over the first information report. Similarly, first information report, full stop. PW5 also claimed, PW5 is the scribe. He claimed he scribed the complaint at Belpahari police station. However, the noting in the complaint written complaint exhibit blank is that it was received at the village itself, at Barshol village, and forwarded to the police station. PW16 claimed PW16 PW16 bracket IO claimed the then IC had received the complaint from PW1 in respect of murder. Though there is these pieces of evidence unequivocally established that the complaint was lodged by that the complaint was lodged by PW1 and received by the IC, and received by the then IC, Inspector of Police Station, on the strength of which IC of Belpahari Police Station. Whether it was received, there may be some confusion whether it was received at the spot or there may be some by Belpahari Police Station. Whether it was received at the spot or at the police station is of little consequence. As the complaint had been lodged promptly, that is within a couple of hours, as the complaint has been lodged promptly, that is within couple of hours from the incident. Possibility of substitution now, promptitude with which the complaint was lodged rules out the possibility of substitution of the complaint, or manufacture of a new complaint. Full stop. Learned lawyers have also, next paragraph, learned lawyers have also argued the genesis of the incident as per the FIR is at variance to the case made out by PW1 and other witnesses in court. In the FIR, 22 persons were named as members of the group who had assembled and had shared common intention to commit murder. In court, PW7 could name PW1 named 7 persons, named the appellant, 7 persons including the appellants. Full stop. Including the appellants. It is also including the appellants. It is also submitted role of the appellant in role of it is also submitted role of appellant role of Bikash in demanding water is disclosed for the first time in court. Shushanto was not named in the first information report at all. Full stop. I have given anxious consideration to the aforesaid issues raised on behalf of the appellants. Prosecution case is prosecution case is an attack on the house of PW2 is that in the dead of night on is that on 20 in the dead of night on 26/5/2012 a group of persons a group of Maoists had attacked the house of PW1 Sudhir Kumar Saha. Sudhir belonged to a political party. The miscreants called upon Bikash, Bikash called Sudhir. One of the miscreants called Bikash called Sudhir, asked Sudhir to come out, stating Horen had sent them. Sudhir was unwilling to come out of the house. The miscreants started breaking the tile shed. Fearing for his life, Sudhir jumped from the first floor of his Pakka building and broke his waist. Thereupon, Sudhir's son Shamul came out. Upon the hearing cries of his parents, Sudhir's son Shamul came out and opened the door to give water to Bikash. Thereafter, the miscreants searched for Sudhir, and as he could not be found, they exhorted they would murder the appellant Shamul. They murdered Shamul. Full stop. The aforesaid narration depicts a case of mob violence unleashed on the hapless family. Mob violence by a group of extremists, by an extremist group unleashed upon the hapless family. In the FIR registered by FIR, PW1, wife of mother of PW1, PW1's FIR has to be appreciated in the backdrop of these attending circumstances. She had seen the unruly mob attack the house and thereafter attack the house, search for her husband and thereafter murder her own son. She named 22 persons whom she named 22 persons in the first information report. However, during investigation, statements of witnesses, her further statement was recorded. Her further statement was recorded. Statements of other witnesses were recorded. Roles of the individual, roles of the other accused person did not transpire during investigation, and a prayer for discharge was made. PW1 prayed for PW1 prayed for the PW1 disputed the prayer for discharge and prayed for further investigation. Learned judge turned down her prayer, observing the said accused may be summoned if evidence is adduced against them. Thereafter, PW1 and other witnesses were examined. PW1 named the appellants in court, examined. Thereafter, PW1 and other witnesses were examined after a lapse of 3 years, possibly due to lapse of time. PW1 was unable to recollect and name all the accused in the first information report. Accordingly, all the accused, name the discharged accused in the first information report. However, she was able to name the appellants, and specifically state the role of some of them, and specifically disclose the role, Bikash's role in the murder. Bikash's role in the murder. It is trite that appreciation of evidence, appreciation of evidence of an eyewitness in a case of mob violence requires to be assessed with a certain degree of requires to be assessed with caution. There is always a possibility for the eyewitness to cast the net too wide and drag in the maximum number of persons in the array of accused. However, such efforts should not be a ground to disbelieve the eyewitness in toto. The principle falsus in uno, falsus in omnibus is inapplicable in Indian jurisprudence. Given this situation, a duty is cast on the court to appreciate the evidence of PW1, to appreciate the evidence of PW1 on the anvil of probabilities and separate the grain from the chaff to come to the truth of the matter. I have undertaken this exercise. I have undertaken this exercise qua the appellants. Qua the appellants. Role of qua the appellants. Role of erpore rekho, role of Bikash. Full stop. Bikash Murmu is one of the principal accused. He is the Bikash Murmu is one of the principal accused. He on the anvil of broad on the anvil of other evidence on record and broad probabilities of the case. I have made an endeavor to examine the evidence of PW1 with the appellants. Role of Bikash. Bikash Murmu, the principal accused. He, in the FIR, it is stated PW1, it is stated PW1 and 2, it is stated PW1 heard, it is stated PW1 heard, in the FIR it is stated at the dead of night PW1 heard a voice stating, I am Bikash, inverted comma, I am Bikash, voice calling her husband stating, I am Bikash, Horen has sent us. Horen had sent us. Please come out. Please come out. Full stop. Quote or inverted comma. In court, please come out. In court, Bikash, in court, Bikash, in court, PW1 reiterated the said version and stated that Horen had sent Bikash and others whom she could not identify, bracketed presumably due to lapse of time, bracket closed, to her house on the fateful night to murder her husband. Night to murder her husband. PW1's version is corroborated by her husband PW2, who also claimed that upon query Bikash stated, who also claimed he initially heard cries Dadu Dadu and Kaku Kaku. When he responded, he heard inverted comma, I am Bikash, Horen has sent me, full stop, I am Bikash, full stop, Horen has sent me, we have to discuss a matter, full stop, please open the door, full stop. These pieces of evidence, it may also be, it may not, these pieces of evidence corroborate the prosecution case in the first information report with regard to the fact that a group of miscreants had assembled at the dead of night in front of the house of PW2. They had called PW2 as Dadu Dadu, inverted comma, and Kaku Kaku. Thereafter, when he inquired, he heard a voice. He heard Bikash calling, but he heard Bikash calling. He heard Bikash calling. Bikash stating that they had been sent by Horen for a discussion, and that for a discussion, and that he should come out. Full stop. In the exculpatory statement exhibit 14, Bikash admits his presence amongst as one of the miscreants, as one of the persons who had assembled at the spot. He also admits that he also admits he also admits at the spot. Full stop. This fact corroborates the deposition of PW1 and 2 that Bikash was present at the spot when they heard him say that he and others had been had been sent to the spot by Horen to have a discussion with PW2. Full stop. With PW2. Next comes PW2. This part of the prosecution case is proved. This part of the prosecution case against Bikash is proved beyond doubt. Next comes the role of Bikash in demanding water. Which had prompted Shamol to come out and give water to him. Mr. Mohapatra argues as per FIR, Bhoirav, bracketed not sent up for trial, had demanded water and had demanded water and not Bhoirav and not Bikash had demanded water. Full stop. I would have given credence to this submission, but for the fact that Bikash, in his statement before magistrate, in his exculpatory statement before magistrate, admitted that he had asked for water, which prompted Shamol to come out and give water to him. It is settled law. Now, though exculpatory confession is of little evidentiary value, admissions which find corroboration from other circumstances, admissions made therein which find corroboration from legally admissible evidence on record may be utilized by the prosecutor against the accused. Full stop. Against the accused. It would asking for water, Bikash's calling the inmates of the house to give water. Now, ordinarily, Bikash's conduct to ask to demand water may appear an innocuous act, but when this conduct is seen in light of other evidence on record, it assumes relevance. It assumes It assumes importance. It assumes strategic relevance. It assumes relevance. Appellants are said to be members of a Maoist gang. PW6, wife of Shamul, deposed the Maoists do not come. Maoists do not ordinarily come into the house. PW2, in spite of repeated calls, PW2 and other inmates had not opened the door. The miscreants were trying to enter the house by breaking tiles. At this juncture, Bikash used a ploy by calling upon the inmates to give him water, to lure them to open the door and come out of the house. The ploy worked and Shamol came out. This gave opportunity to the miscreants to search for his father, that is PW2. But PW2, in order to save his life, had jumped out from the first floor had jumped from the first floor towards the rear of the house and had fallen down and broken his waist. They could not find him, and in a frenzy of violence assaulted the victim. The aforesaid circumstances show the overt act of Bikash to demand water and thereby lure Shamol and thereby compel Shamol to open the door so that they could make inquiries about his father and ultimately kill Shamol in absence of his father is clearly established. Finally comes the brutal assault on Shamol. PW1 in FIR, PW1 stated Bhairav and Bikash assaulted the victim, assaulted Shamol. In court, she tried to implicate all the appellants in the assault. This may be an exaggeration, this may be an embellishment, but searching the kernel out of searching out the kernel of truth in her deposition shows the consistent role of Bikash in assaulting Shamol, with unknown others to commit the crime, to murder him. I am in this background. Bikash, in the exculpatory statement, Bikash admitted his presence. In his exculpatory statement, Bikash admitted his presence at the place of occurrence. He also admitted that Shamol he also admitted he had called for water. He had asked for water and Shamol had come out to give him water. Thereafter, he also admitted Shamol was assaulted at the spot and died. These admissions bind the maker. These admissions bind the maker, and these admissions not only bind the maker but find corroboration from other evidence on record, particularly that of PW1 and 2. It is also relevant to know PW1 and 2 as well as medical evidence of PM doctor with regard to the cause of death. Full stop. It is in so-and-so, this court, the apex court held incriminating parts of an apex court held that it is that when confession is exculpatory, incriminating parts of the confession may be accepted, while the exculpatory parts which do not find corroboration from the evidence on record, no, while rejecting the exculpatory parts which do not find corroboration. Because the exculpatory portions of Bikash's confession, that he had not called the victim, he had not called out PW2, is not corroborated, is improbabilized by the assertion, by the FIR and PW1 and 2. The other aspect, the other portion of the exculpatory statement, that it was Shamapada and not, it was Shamapada who had assaulted Shamol with an axe, is also improbabilized by the clear, by his clear and unequivocal implication in the first information report, as well as the deposition of PW, as well as deposition of PW1, as well as deposition of PW1, while the participation of other accused in the assault is at variance. While the participation of other accused in the assault is at variance, the role of Bikash in the assault is consistent, and is narrated consistently in the FIR and the deposition of PW and the deposition of the eyewitness PW1. Hence, I am of the opinion prosecution has been able to the manner and circumstances in which Bikash had called for PW2 and played a ploy to persuade Shamol to open the door and come out of the room, and thereafter assault him with others with an axe, show that he shared common intention with the other appellants, with other accused to commit murder. The prosecution case is proved beyond doubt, doubt against him. Role of Horen. Prosecution states Horen is the mastermind of the crime. It was he who, as per FIR and deposition of PW1 and 2, Bikash stated it was Horen who had asked them to come to the spot and discuss a matter with PW2. PW2 declined to open the door. Thereafter, the miscreants tried to climb through the tile shed. Horen, PW2, fearing for his life, PW2 jumped out from the rear side of the first floor of his house and broke his back. At that moment, Bikash had called Horen. Bikash had called for water. Shamol opened the door and was brutally assaulted to his death. PW1 records in the FIR, PW1 stated PW1 stated that the miscreants had been sent by Horen to their house. She reiterated the same fact in court. She also stated the presence of Horen. She also identified Horen in court as one of the miscreants. Her deposit, PW2 is corroborated by PW1. PW1 is corroborated by her husband PW2, who also claimed Bikash stated that he and others had been sent by Horen to the court to commit the crime to their house for a discussion for a discussion. Thereafter, for a discussion, Mr. Bhattacharya contends PW2's exhortation, PW contents appellant's exhortation, contents Bikash's exhortation that they had been sent by Horen is inadmissible in law against a co-accused. কি বললাম? Mr. Bhattacharya contends a co-accused contains a co-accused, that is PW, that is Bikash, his exhortation that Horen had sent them to have a discussion is this statement is inadmissible in law. Is the statement of a co-accused which is inadmissible in law. Full stop. I am unable to subscribe. It is true. Statement of a co-accused, Horen's exhortation, Bikash's exhortation is corroborated by other evidence on record. Is corroborated by other evidence on record. PW1 deposed, PW1 and 2 deposed. They had heard Bikash state that Horen had sent them to the house for a discussion. When the PW1 also noted the presence of Horen in the first, PW1 also noted the presence of Horen amongst the miscreants. Full stop. Among the miscreants. In light of the aforesaid evidence, aforesaid clinching evidence on record, it cannot be said that it is clear that Horen was the leader of the group of Maoists who had come to the house of PW1 in order to commit murder. When they could not find PW1, they murdered his son, Shamul, in order to strike fear in the hearts of the family so that they would not participate in democratic politics. Full stop. In democratic politics. The intention of an accused, whether an accused shared common intention to murder has to be inferred from various circumstances, various attending circumstances. His role, his presence at the participation from various his role in the crime, may be patent or latent. His role in the crime may be patent or latent. However, may be patent or latent. Whether from various attending circumstances, a accused who shares common intention. In Horen's case, evidence has come on record to show from various attending circumstances. Evidence has come on record. Horen was the person who had sent Bikash and others to the spot to commit the crime. To commit the crime. His intention to murder PW1 or in his absence any of the family members is is self-evident and is self-evident and proves beyond doubt that he shared common intention with Bikash. He shared common intention with Bikash and unknown others, and Bikash and others to commit the murder. Full stop. Prosecution case against Horen is proved beyond doubt. Sushanto. Coming to the role of Sushanto, we note that Sushanto is not named in the first information report. Learned public prosecutor admits the first information report is not a cryptic document. It is an elaborate document naming 22 accused. Absence to 22 accused. It had Sushanto's presence been noted by PW1, it would certainly have found place in the first information report. But in the first information report, it is also relevant to note, but it is not so. It is also, but it is not so. Only PW16, investigating officer PW16 admits, oh, arekta horene arekta dao, oikhane horene recovery prosecution case against Horen is further bolstered by the recovery of the weapon of offense, that is axe, from near his house. Investigating officer PW16 proved the disclosure statement made by Horen, proved his disclosure statement, which led to the recovery. Mr. Bhattacharya argues that the recovery is not supported by independent witnesses. This is of little consequence, as Horen himself admitted to the to the recovery of the weapon of offense, that is axe, pursuant to his leading statement during his examination under section 313 CRPC. Due to lapse of time, the bloodstains had disintegrated, disintegrated. This explains the non-recover. This explains the failure. This explains why the presence of blood could not be detected in the FSL report. এইটা পরে তারপরে ওই common intention টা দেবে, হ্যাঁ?
One thing, my lord, 27 statement has not been exhibited.
Matt exhibit 4.
Matt exhibit was there, X was there, 27 statement was not exhibited.
It is there. You see part 3.
যা বাবা, কি করবি? No, definitely 27 statement was there, but perhaps that has
It has not been Oto apology made a confessional, made a disclosure statement. Oto exhibit
X was produced. X was produced and
and
Matt
part
exhibit.
3, the statements have been are there. I don't know why they were. I've seen these statements in part 3 of the trial court records. It is there. Near his house. Investigating officer deposed. Deposed on the basis of Horen's statement. The axe was recovered. Axe has been produced, identified in court. Mr. Bhattacharya's tarpore argument. Next. Ebar Sushanto. Role of Sushanto.
Matt exhibit 4.
But it is not so. His presence is investigating officer also, PW16 also admits Sushanto was implicated in the case on the strength of source information as well as uh, source information as well as
Co-accused.
Statement of one.
co-accused
Co-accused.
statement. Full stop. Solitary evidence against Sushanto comes from the mouth of PW1, which appears to be an embellishment. PW1, which PW1 for the first time in court, she had not mentioned even his presence in the first information report. This is an embellishment. This piece of evidence is an embellishment, and therefore I do not consider it prudent to rely on PW1's sole deposition against Sushanto to establish guilt, to against Sushanto, full stop. Even though in the exculpatory statement, Sushanto's confession, Sushanto had retracted his confession. Even if the same is if retraction is ignored, this statement is exculpatory. Exculpatory. He states, due to out of threat by out of threat from Bikash. Now, due to Bikash's threat, he out of threat, due to threats, he was forced to accompany the miscreants and call out PW2 as Dadu Dadu, full stop. Thereafter, he ran away from the spot. The exculpatory version, that is, he ran away from the spot, appears to find corroboration from the fact that PW1 did not name him as one of the persons present at the spot in her FIR. This is why this corroboration persuades us to rely to accept the defense version that Sushanto may not have been present at the spot when the incident occurred. It needless to mention, reference of Sushanto in PW6, needless to mention, I do not attach importance to PW6 or PW14 to version in respect of Sushanto, as the said witnesses, as PW1 is PW6 is not an eyewitness, and PW6 was a reported witness. Full stop. আচ্ছা এটা কেটে দিয়ে 6 না এটা এরকম ভাবে কেটে দিয়ে বলো PW6, it is true PW6 ওই নির্দেশে কেটে it is true PW6 referred to Sushanto's role in the murder. However, during cross-examination, she admitted, but in other parts of her deposition, she admitted that she had heard the names of the assailants from her father-in-law, PW2, who is not an eyewitness. Before police, she had not named Sushanto. Her deposition is therefore of little substance. Similarly, PW14, who states Sushanto probably assaulted the victim, is a hearsay witness, who does not deserve credence. Accordingly, I am of the opinion evidence of a prosecution case against Sushanto is too shaky, and it cannot be said that he was present at the place of occurrence and shared common intention to commit murder. However, his acquittal does not affect the the prosecution case proved against the other two appellants on the strength of consistent and reliable evidence. Full stop. Sushanto acquitted, others convicted. We come back after 5 minutes.
Mine is in Bankura, that I know.
You are in Bakura, so
I'm in
yours
Bankura, that
may
I
not be disturbed. But
uh,
Sushanto,
Sushanto, my lord, I don't know because last
Amita, find out where Sushanto is and give us so that advance copy that. We are coming back after 5 minutes.
Item number 5.
But 7 I am appearing for the bench.
The case under section 420, 406, 409, 467, 468, 47. My lord, I was the director of a, if your lordship kindly sees the
The shareholder.
order passed by the honorable division bench of this honorable court at page 36, in respect of a co-accused, my father, who was a director, your lordships had granted bail. There the facts are there, your lordship can go through the same. He is the son and was director for a limited period of time.
Petitioner is one of the directors of the company. Was one of the directors of Messrs. Purulia Casting Private Limited.
Metal casting. My lord.
Metal Casting Private Limited. He contends he had no role to play in the transaction, which is the subject matter of the case. He had resigned from the directorship of the company in
3rd of July 2020.
3rd of July 2020. His father, that is Bhavani Prasad Mukherjee, has been enlarged on bail. He prays for anticipatory bail.
Well, we had in the meantime prayed for towards the amount which was paid. Already there is a civil suit pending.
We know, we've read it. You said.
Oh.
We obey your commands. Don't worry. Learned lawyer, the state opposes the prayer for bail.
He on the self-same modus operandi, my lord, he has some antecedents also.
Who has
one of the antecedents, my lord, this honorable court rejected his antecedent.
Who has antecedent?
My lord, this boy, my lord, is only one.
This boy.
This man.
This boy is.
This Bowbaja police station case number, my lord. Another case.
Huge.
But on the self-same modus operandi, my lord.
What is the same modus operandi?
PS case different. But there in Jharkhand there are 5 cases. Bowbajar 1.
She ordered to go.
Learned lawyer for the state submit petitioner and other directors of the company had induced the complainant to deposit money to deposit money on the false assurance of transfer of 50% shareholding in the company.
Allegation ছিল.
He had committed similar offenses earlier. Full stop. We have considered the materials on record. Petitioner was a director of the company for a brief period of time. The affairs of the company was primarily managed by his father, that is Bhavani Prasad Mukherjee, who is on regular bail. A civil suit is pending between the parties over self-same issue. Custodial referenced earlier criminal cases registered against petitioner do not relate to the affairs of the company. Custodial interrogation for progress of investigation is not necessary, and petitioner may be granted anticipatory bail subject to conditions. Same conditions.
I'm deep.
शेयर ट्रांसफर पैसा लेकर किसी और को ट्रांसफर किया है
My lord, the case has been started 06 478 420 506 of the IPC, my lord. My lord, the petitioner and the complainant were in a relationship. After breaking up, this FIR has been lodged, my lord. Kindly have a look, my lord, page 9, the complaint, my lord. Yes, she has alleged that this amount of money has been taken as loan from the different bank and given to me. But kindly consider this fact, my lord. Whether this amount of money has been credited to my from the account of the complainant, my lord.
Petitioner submits that there was a relationship between the parties. The relationship soured. As a result, he has been falsely implicated. He prays for anticipatory bail. When a lawyer for the state opposed the prayer, we have considered the materials on record, including
That he has taken the money.
the allegation, including we have considered materials on record, including an undertaking to refund the sums advanced to him as per FIR. Petitioner took advantage. FIR. There was intimate relationship between parties. Petitioner asked for loan to invest in asked for loan for financing a movie. He received over rupees 25 lakhs. Undertaking collected during investigation. Undertook to refund the money, but has failed to do so.
But he has also
Yeah.
failed to comply with 40
Failure to refund loan per se would not constitute offense of cheating. Custodial interrogation for progress of investigation is not necessary. Meet investigating officer once in a while.
I'm grateful, sir.
One thing is very necessary is money decrease. We should have a faster colic. Colic. What is a colic? So you
page 8, man.
what did you do? What did you do? Attempted to rape.
No, 498 to 406, man.
So what?
490 to 406.
Your friend of the husband.
Man, she's a lady, man.
Oh, she's a oh, you are the paramour. You are the reason for 498. Petitioner is the paramour of the husband of the victim. In-laws have been, husband is in jail.
No, anticipated by your lordship,
Oh.
page 8.
Husband and other in-laws have been enlarged on bail. Keeping in mind the opposite fact, we are inclined to extend the same relief to the court.
Great.
for accused and state in one line. You know, both.
My lord, item number 39 for the petitioner, my lord, 417, 376, my lord. Yesterday I have served to the victim, my lord, but service is not complete,
Give
my lord.
1 week.
My lord.
Deal turned sour. The allegation is that the petitioners forged documents and had substituted the de facto complainant and his brother at the helm of the company as directors. Now, subsequently, a civil suit has been filed. We are contesting that by filing.
Short Passover, my lord. I'm praying for short Passover.
Once again.
About 41 notices were issued. We had complied. We have submitted our supporting documents. The agreement.
Where
that
is
has
the
been reached.
FIR?
The FIR is at page 23.
16.
16. No, 16 or 17. It starts off 17.
Seven.
16 is their complaint to the ROC.
You approach NCLT.
Original site suit court. They have approached. Suit is paid.
Krishna Rao directed that we have to be put back
There.
and ROC put us back. No, my lord, there's a little more. I'll just indicate to you, Lord. Give me 1 minute.
Lord.
Yeah? So this is what was filed before this honorable court on the previous occasion. Every document that was filed before this honorable court was forged. Every document that was filed before this honorable court was forged. My lord, they not pressed the application because they placed forged documents before this honorable court. Along with the PAN cards of the company, along with the forged signatures, they created document to be placed before this court, saying that we have withdrawn all allegations. After that, my lord, kindly seize this. Give me a short list of dates.
Once again, what
Yes,
is
sir.
this number?
Lord, this.
CRMA 222.
You have attached the order. You have not placed, you have attached the order.
Correct. You may have attached, but if you have relied on forged documents, what
But
do you
those
have
are not
attached?
forged. Those documents that were attached were issued by Anil Manali, who is a separate, who is not the petitioner before lordships. And those are not documents, those are already part of record. Case diary, our documents which we have complied with at the time of 41 compliance.
Let us call for this CRM A222. All right. List along with CRM A222 of 2024. Because Mr. Banerjee, we understand that somehow they obtained the digital signature and uploaded the application for appointment. This has since been taken care of. The appointments have been injuncted and
A contempt application was moved. And then
whatever
ROC put us back.
appointments have been injuncted. So
Yes.
whether progress of investigation will require custodial interrogation, we will see. But a very serious allegation you are making that in the earlier application, he has relied on forged documents. If that is so, we are not going to permit you to file this application. On the other hand, you may be minded to direct registration of a separate case. Whether you don't press it or not, why the documents, forged documents will be filed?
My instruction is that those are not forced documents.
So let us see.
My lord, my lord.
Do you have a copy of 222?
Not right now, my lord.
All right, give him a copy of 222.
This is my.
We will require police also to see what sort of documents were used.
My lord.
This is absolutely not welcome. Whatever has happened, whatever you come up with clean hands. If you are using process of law for fraud, no.
My lord. Definitely.
Can you give us? Withdrawal.
लैंडमार्किंग करते रखना
Yes.
नहीं तो इससे तो पट कर
It's observed also, the Honorable Court has observed that.
What?
That some exact order which they have annexed, my lord, 2223, they have annexed it.
Not
saying
pressed.
that- Not pressed
Not
because of
pressed
some
because of-
incurable defects. And they
Defects
just
in the
got-
pleadings with regard to 41A, because there were pleadings that all have complied,
But
Anil Malani did not comply. That was the only purpose.
We
My lord, we have
produced
attached the.
joint PAN cards showing that the
very
attachments
well-
which were there were all false.
Very well,
And
let
then
that be
after
verified.
11 months, the investigating officer, after refusal, my lord, on this court, the investigating officer sat tight, gave them 41 and notice, and now the CA
Where is
was
the
with them.
investigator? Which police station?
My lord, 41A notice was issued earlier.
Where is the investigator? Ask him to be present.
My lord.
And one person goes and surrenders and gets bail. The CA, who was with us in this, with them in this, goes, surrenders and takes bail in this case.
Listen, so far as this case is concerned, we also feel that whether at all person needs to be taken into custody is a
I agree with
question
you.
we have to look into.
Yes.
But the conduct of a person being so brazen to use documents which are forged and fake to justify to persuade a court to get anticipatory bail, we will direct an independent FIR to be registered against them.
My lord.
We too.
Grateful.
Well, we'll take back the.
Sabina.
Yeah.
My lord, the non-bailable sections are 109 and 132, which corresponds to 307 and 353 of the Indian Penal Code. Now, my lord, the police persons went to the village to pacify a tension between the two communities. My lord, one of the group, my lord, they assaulted the police with bamboo sticks and chili powder.
Then
My lord, 13 people, they were arrested immediately, and other 15, my lord, are named in the FIR.
yes,
We are also
sorry.
FIR named.
My lord, these two persons under their leadership, my lord, were due to communal disturbance for.
No, Mr. Surrender. Petitioners contend that there was a law and order situation. There was a law and order situation due to communal tensions. Petitioners have been falsely implicated. They pray for anticipatory bail. Learned lawyer for the state opposed the prayer. We have considered the materials on record. Statements of witnesses show under the leadership of the petitioners, unlawful mob assaulted police personnel. They even disrobed lady police officers. In light of the nature of crime, We are of the opinion this is not a fit case to grant anticipatory bail.
I for the petition. Lordship, there is a case and counter case between the
Case and counter case. Let us see how much injury you suffered, how much injury they suffered. All simple. We have considered the materials on record. It is contended there was a free fight, case and full stop, case and counter case was registered. Injuries are simple. Accordingly, we are inclined to grant anticipatory bail. Next.
But I am for the petitioner.
Not to the matter of
Not today. Tomorrow.
90, Madam Petitioner. So one of the co-seller Millard, two sister Millard sale of property 2023, now made a complaint, lesser valued, it was executed, its value is high. The petitioner not paying the money. No deed mention, nothing.
Yes, what is the FIR?
I read that you have sold the property at 1 crore and pay the money, and he has purportedly lost the original deed of conveyance, the petitioner.
So they are co-owners. They are co-owners. The accused and the complainant are co-owners of the property.
I have a deed, my lord.
You have a deed?
Yes.
Oh, they were the brokers.
No, Lord, I am the purchaser.
Purchaser.
Purchased by paying 2 lakhs, 2023.
The value is said to be 2 lakhs. 1 crore property becomes 2 lakhs.
What can I
What
do?
deed?
Lost the deed.
Where is the deed?
He claims he has lost the deed.
No, this would a registered instrument.
Registered
How
instrument.
come they-
That he has asked to collect it from the registry office. That's different. He is producing a deed before your lordship.
No, I don't know.
And he is claiming that he has lost the deed and
My lord, no deed mentioned in the FIR, my lord. But I
It's a-
purchased.
we are making it very clear. We do not like fake and forged documents to be placed before.
No, my lord, not fake, my lord, document. I registered the my lord petition.
So
also
where is the
taken.
registered deed?
My lord, I produced the deed number is there, my lord.
What deed number is not production? Where is your registered date?
Original name.
এক
সপ্তাহ আগে, my lord, lost the deed, but it is a if
You go into custody.
my lord, I produced the deed, my
Mr.
lord.
If your client loses a deed very interestingly just 1 week ago, then it is under most suspicious
Sir,
circumstances.
what is the
He needs to go to jail in order to recover the deed.
Lord, what is the complaint, my lord? My problem is that, my lord, last 2 months, my lord, last 2 months, series of cases, my lord, the OC
Where
filed
is
against
the
against the petitioner, my lord. Now, your lordship, 1 year back, 1 week back, my lord, your lordship granted anticipatory bail in a similar circumstance. What is the reason?
The deed.
My lord, there is a number, my lord. I produce the certificate copy, my lord. Kindly adjourn 1 week. If not produce, your lordship pass the order. A person executed deed 2023, my lord. It is a complaint. It is written.
All these lectures with the deed.
Yes, my lord.
Bring the deed.
Yes, my lord.
Adjourn for a week.
Much obliged. If not, my lord, your lordship.
We don't want bring the deed. Otherwise, so from here we will get your client.
I will bring a certified copy of the deed. my lord.
Next.
So, dig your order, order, order. আমার
But I'm for the petition.
Yes.
It's a civil dispute, my lord.
complainant sold, my lord, clothes to the petitioner on credit, my lord, which the petitioner failed to pay as his business, my lord, running in loss. So
We have considered the materials
Lord,
on
may I
record.
submit, ma'am, for the defector complaint? The entire things, my lord, he said that it has not been sold, it is lying in godown. We are saying if it is not sold, then return the goods at least. And there is not a single payment from the day when the entire transaction has been started.
We have considered
Motive
the
is very
materials
clear
on
from the
record.
date.
Dispute arose on the score of non-payment of goods sold and delivered. The nature of allegation, the mere failure to pay for sold goods would not constitute cheating. Custodial interrogation
Well,
for
let he return
recovery
the
of
goods.
money is not permissible in law. Under such circumstances, we are inclined to grant anticipatory bail.
Let he be, my lord, let he be corporate investigation.
Need
Goods
investigating
are there.
officer once in a week.
I'm good.
Need investigating officer once in a week.
I'm good.
Deep law,
Deep
like
law.
lordship.
Sold and delivered. Aniket Mitro amount.
Yes. Allegation 135, one electricity account, 1,65,000.
50% of the final bill for unmetered consumption to the tune of so and so, adjourned 2 weeks.
Grateful.
Malad, I have mentioned the amount.
In the meantime, not to arrest, kind of
Nothing. कोई अरेस्ट नहीं करेगा किसी का कोई उसका पुलिस वो जाके
Grateful, man.
Let's say I'm for the petitioner. Section
Yes.
Section 140 is the non-bailable offense.
Yes, recovered.
And recovered after 5 times, 5 hours.
He names
One.
kidnapped him and demanded ransom of 6 lakhs. And he was recovered.
My lord, kindly
We
see
have
the complaint
considered the
letter.
materials on record.
Kindly see the complaint letter.
Petitioners had abducted the victim and demanded money. In view of the materials on
Kindly see the
record
complaint.
and nature of crime, we are not inclined to grant anticipatory. Fine. Next.
Time for the petitioner, my lord. Allegation under section 314(4), 316 to 100.
Cheating.
My lord, allegation is after the de facto complainant's mother's death, the de facto complainant found a diary where it is written that the petitioner and her son took the money. My lord, kindly sees the FIR, the main allegation against the son of the petitioner.
The mother also involved. Let's see page 24. Then 27.
After her mother's death, she found a diary.
Last line. 24, 27 last line. And page 30. 27 last line and page 30.
Allul Mukherjee is the son of the petitioner.
Page 30 side.
Yes, 27 last line we understand, but sir, 1 second, 27 last line we only see Konika Mukherjee. Then
Allul Mukherjee এবং Konika Mukherjee.
হ্যাঁ তো what? কল্লোল মুখার্জির মা কণিকা মুখার্জি। Then
আমার কাছ থেকে
where? আমার থেকে টাকা নিত মা ছেলে। And 30.
30. But slightly, it has been written slightly. আমার মৃত্যুর জন্য এরা দুজনেই দায়ী।
Petitioner is not the principal accused. Petitioner is the mother of the. Where is your son?
My lord, he is not saying the petitioner is staying with her daughter, my lord.
Bring your son.
Son is not staying with the petitioner.
Go into custody. Go into custody.
My lord, kindly. Petitioner is a lady, my lord.
Lady,
my lord,
yes.
my lord, petitioner.
Your son does not have care for his mother liberty. Why should we bother?
My lord, main allegation against the son, my lord. He is the
That is
principal.
exactly what we are saying.
My lord, the petitioner has.
Son doesn't have concern for your liberty. Why should we get ourselves
My
involved?
lord, the petitioner is herself suffering. She is staying with her daughter, my lord.
Correct. We understand. But the statement of the deceased says that you were also involved in collecting money.
Assurance to the deceased.
Petitioner, we can adjourn. Your son must come and surrender.
My lord, kindly adjourn for a week, my lord. Then let me take
1 week.
instruction, my lord. Grateful.
Next.
May it please your lordship, my lord, I'm for the petition.
My lord, I
Lord,
have got a de facto complaint.
What is the offense?
My lord,
500
42406. Now, my lord, so far as the complaint is concerned,
murder case, how many pages, Mr. A? When your officers get a murder case, get a rape case, how many pages? Your entire institution cannot get a DNA examination of rape victim. When it comes to cheating, 5,000 page.
my lord, I'm not an FI named accused.
Hmm.
My lord, so far as the de facto complaint, my lord, he alleges on 10th of August 2021, as he was trying to avail loan through internet, my lord, he comes across two people whose two mobile numbers are there in the complaint petition itself. And now, my lord, after that, he was asked to submit an Aadhaar card and the PAN card. He submits it. Now, after 8-9 months later, the GST officials go to his residence and says that two companies have been opened. So far as and some GST dues are payable by him. Now, my lord, so far as this petitioner is concerned, my lord, I'm not FI named. Neither those mobile numbers are mine. I'm nowhere attached with this. My lord, now.
All right, not today. Who are you?
De facto complaint.
How you get to become the de facto complainant?
I'm complainant, informant.
No. Why informant?
My lord, when I received the notice from the GST authorities, when they came to approach me, I found that I did not open any company.
You did not
Companies were
open
not
any?
opened by us. I was looking for the loan, and I have operated. I applied for the loan online. Lordship, when I made the applications,
Okay.
this was not given
Your
to me.
Aadhaar card, etc. data was utilized.
Now, this was utilized.
Followed. Not today.
Every day I get phone.
I don't take calls. Unknown number, no call, no take.
Thankfully, this is the right of first time.
I am for the petitioner. The allegation.
Subject matter of theft is motorcycle. Well, that has not been seized as yet.
No recovery, no recovery.
And
No medical test and
injury reports, at page 14.
One 64 medical awareness.
That's
my lord, motor car was taken up by us, not complaint. Only vanity bag.
My lord, after deleting my lord Arms Act, charge sheet has been submitted in non-bailable section 353, 326, 307, 379 of the Indian Penal Code. The present petitioner before your lordship, not in the FIR name accused person, charge sheet filed against 15 accused person, my lord. I am in serial number, my lord. I have annexed the serial number, my lord, 12 of the charge sheet. I have gone through the.
yes, my
Azizul was a FIR name. Azizul was FIR name. So far, no.
Mob attacked my lord, police personnel who are performing my lord duty, my lord, official duty, my lord. My lord, he is the associate of Azizul, my lord.
Azizul. Grateful, man.
My lord, I am for the petition is a matter of item number 27, my lord. I am paying
28 are both
27 and 28, the both matter. I am paying for the 1 week
1 week advance.
because senior counsel is not happy today on the 20th.
Standard copy. Petitioner Lord, arrested under section 20B2C of NDPS. My lord, petitioner arrested under section 20B2C of NDPS Act. Magistrate, my lord.
My lord, I am representing the appellant in item number 31. My appeal has been admitted on 4th of November. Yes, yes.
Madam, I'm for 31.
My lord, my suspension has been filed, my lord. But already out of 10 years, we have I have served 7 years, 11 months, your lordship. Already. Offenses are under section 20B2C of the NDPS Act, my lord. Judgment was delivered on 16th August 2024. Lordship, in the meantime, suspension. Your Lordship, already. Yes, Your Lordship.
So we can give you a price for your conviction, like suspected. The annual report showed that their process we have to how we have to suspected.
My Lord.
Dilemma I have filed in time because as the seal has not been given. All right.
Explain all your things by saying that there is no time.
Yes.
As in,
2 weeks, then because I'll not be.
Give us, but my lord, I am pressing for the 37, my lord. My lord, the particulars is this is the Aadhaar card of the wife of the petitioner, my lord.
আমি দিচ্ছি দিচ্ছি দিয়ে দিচ্ছি
3097.
দাদা 36 not
For the
File a supplementary affidavit annexing the documents, my lord, that he is traveling on 25th to 28th. He has to be out, my lord. Paragraph number 4, my lord, of the supplementary affidavit, my lord.
no, paragraph of the main petition.
That the documents annexed.
Say supplementary affidavit copy.
My lord, the supplementary affidavit, I have annexed the documents.
37.
Yes, ma'am.
Supplement. Page 3.
My lord, the petitioner. Twenty-eighth of January, madam. Going on.
It's going on.
Going on.
In the case, the present application of the application of cheating and theft.
My lord, not theft, my lord.
Cheating and supplication. The important page of this bill, the content anticipated that shall be possible to the investigation.
No, before the investigating officer.
Once in a fortnight. Fortnight. My lord, the passport is with the investigating officer, not in the court, my lord.
He is a tool operator and organizes force to international testing. Investigation is continued for a protracted time. For a protracted time for more than 6 months and for more than 8 months. And more than 8 months. In the event of partnership closed. If this partnership is right to carry on period, if I right balance instance from the levels of destination, one and the right to carry on. As a from January 2000.
मतलब 20,
20,
25,
25 to, 25 to 25 to 20,
28.
25. Preeti Kaur, Preeti Kaur.
My lord, may I the amount may be considered. The registered surety. Well, the registered surety.
25,000. Uh, 25,000. Subject to law.
No, 50,000 personal bond.
50,000. So, 20.
My lord, can it be on 48 hours, my lord, because my lord, grateful.
Please,
Yes. Your Lordship, Lord, appointed me, Lord, this matter, Lord. Is that matter, Lord? Appeal, Your Lordship wanted to hear out the appeal. On the last occasion, Lord, Your Lordship also detected, Lord, there are separate charges, Lord, because of the reason, Lord, one person absconded, and that is the reason, Lord, ultimately, Lord, was Your Lordship would find, Lord, from the judgment of the trial court, and the learned judge has explained why there are as many as 4 charges were framed. Your Lordship would kindly take, Lord, the page 42 is the judgment, Lord. Then Your Lordship, Lord, will get the explanation at page 43, the 3rd paragraph. The prosecution, Lordship has got, Lord. Lalu and Sirajul was initially arrested. Thereafter, charges were framed against them. Subsequently, Labu was arrested. And then, Lord, finally, charge was framed under section 300-34 and section 34 of the ES Act. Last paragraph would be the, Lord, explanation which your Lordship has pointed out.
Why doesn't he frame charge under 300-34 against Labu?
But that charges were only, only 300.
Why?
Only 302, Lord, at page 11.
No, we don't understand why.
Lord, perhaps, Lord, what has played in the mind of the learned judge, because since, Lord, by this time the evidences, Lord, come as surface that Lalu is the person, Lord, who has thrown the. But ultimately, Lord, it was the prosecution case that all came bodily, and then FIR at least says so.
Not Lalu. Just see. He has also framed charges under 302-34 against Labu.
And page 10, your Lordship is looking at page 10 perhaps. And Lalu, Labu and Sirajul. 302-34.
17 November 2017.
The next page. A separate charge. Explanation.
That is only Labu.
Put a page 43 তে আছে দেখ
জানি না মানে কি যে করছে some defects, yes, see, modify, next page, they modify the charge because he realizes it's a mistake. He can't frame charge under 302 against 1. So
that's
in
the reason
2017 he has again corrected the charge and made it 302-34.
That is the reason, Lord, I have shown you, Lordship, page 43.
It is at page 44,
last paragraph. Just
first
before the,
yes.
After modification of the charges on 17/11/2017, due.
वो तो correction किया ना? Two.
That is the reason again on 17/11.
Now who is convicted?
Lalu has been convicted and other 2 has been acquitted.
Because Lalu threw the bomb.
Yes, that was the finding of the learned judge. Lord, the 3 witnesses, Lord, the learned trial court has taken into consideration. তিনটে eyewitnesses কথা বলছো. Lord, your Lordship would kindly take, Lord, PW1.
Lalu is in custody, no?
Lord, yes. After that order, Lord.
Let us do like this. Has he been intimated? He was represented in this case by whom? By Orindam.
Lord, today morning, Lord, I must be. Today morning, Lord, a family member someone has called me up, and I said that since the honorable court has appointed me, I'll be doing the matter. But if you want to engage someone, you
Let us
you
keep it.
please
Huh.
do that. You can talk to you can engage another lawyer if you feel so. Today morning, they have called while I was coming to court. They have called me up and said,
Because Mr. Mukherjee is appearing for them in bail application.
One of the lawyer, perhaps. One of the learned advocate who practices in Lord Kadi court. His bail application was perhaps moved, and Mr. Mukherjee appeared.
What we do is, we just intimate Lalu through your officer that nobody is representing, and Mr. Ahmed has been appointed on his behalf as from the High Court Legal Services. Huh? He is, however, at liberty to appoint his lawyer. Date is fixed for hearing on such and such.
If he appoints or if
because he is in
like,
custody in another case and all that.
And some checkered history, if he has some.
We don't want to give an impression that keeping him in custody in another case, his appeal is being heard out. The appeal came up for hearing on earlier occasion. Appellant was unrepresented. No, the appeal has a checkered history. Appellant, with the aid of appellant, had furnished after admission of the appeal, appellant procured release after admission of the appeal,
and
his prayer for suspension of sentence was turned down by a bench presided over by
Honorable Chief
by
Justice.
us.
No. By my Lord Justice, Honorable Chief Justice, as his Lordship then was, and my Lord Justice Banerjee.
Was turned down by order dated 2/3/2021.
3/2/2020.
At page 118 of the paper.
Acha, 3/2/2020 by a bench presided over by the then Honorable Chief Justice. Relying on a forged order, purportedly dated, relying on a forged order.
CRAN 3, may I just recap now? The CRAN 3 which was filed regarding bail in connection with appeal, that was pending. Now, my lord, during that CRAN 3, my lord, he has produced that forged order of in the name of my lord Chief Justice.
Relying on, but CRAN 3
was pending.
No order was passed dismissing.
No.
Acha, after admission of appeal, appellant prayed for suspension of sentence in CRAN 3 of 2020. During the pendency of the application, he procured on the strength of a forged bail order. He was released on bail. When this was brought to the notice of this court, of this bench, by order dated 25/9/2023, the bail bonds of the appellant, bail bonds furnished by the bail granted to the appellant and bail bonds furnished by the appellant on the strength of the forged order were cancelled, and he was directed to be taken into custody. A separate criminal case was also registered against the appellant and his lawyer, so and so. Presently, the appellant is in custody. His lawyer is also in custody. And is in custody. As a result, the appellant is unrepresented. As a result, when the appeal came up for final hearing, appellant is unrepresented. Under such circumstances, we directed Mr. Ahmed, learned advocate, impaneled with the High Court Legal Services Committee, to represent him. Mr. Ahmed contends appellant's family members had contacted him over telephone. Given these circumstances, we direct the officer officer in charge we direct
Right now, I think they are in Kolkata, so they have been brought. So let
Acha, we direct the department. We direct the department to communicate a copy of this order to the appellant and
which jail I'm just giving.
appellant in so and so correctional home, or appellant who is in so and so correctional home, so that he may given this situation, given this situation, we adjourn the hearing of the appeal in order to enable the appellant to appoint a lawyer of his own choice, if he so desires. Failing which, Mr. Ahmed shall represent the appellant as legal aid counsel. Department is directed to communicate a copy of this order to the appellant who is presently in so and so correctional home, to enable him.
If my little friend can give that phone number also, if that will.
No, I'll give.
To enable him to take appropriate steps, to take necessary steps in the matter. Matter will appear 3 weeks hence.
Lord, one copy may be sent to his home address so that the family members can, Lord.
Department is directed to communicate.
That is difficult, Malad.
No, it'll go by post, Lord.
To the appellant, he is in jail, so let it be communicated to him in jail.
As a lordship, please.
Then, if he wants, he can always communicate.
Number.
So if they want, Mr. Ahmed, they can appoint you as their lawyer in private capacity, or if they want.
He initially said that he wanted to talk to me. I said that since the court has appointed me, you can come and talk to me.
Absolutely.
But you can, I have said this specifically, you can appoint a lawyer of
we
your
just want this to be kept on record.
Yes.
You understand?
Obliged.
Today, if an adverse order is passed,
Obliged.
the question may arise whether he
Opportunity,
was
Lord.
given opportunity to appoint a lawyer of his own court. And these are peculiar circumstances. So we just keep it for 3 weeks. Next matter.
আমি তোকে নাম্বারটাও দিব সেটা ও বলবে আমার কাছে নেই
My lord, in this matter, my lord, the life convict and terminally ill, your lordship is asked to place the report.
He is suffering from dialysis. He's undergoing dialysis for the last 3 years. He's completely bedridden. This is the second page of the report. Suffering from and it has two dialysis and it is condition. It is poor. He requires dialysis, two dialysis per week, but in more general condition, he is number of dialysis per week. He cannot walk without assistance. Under such circumstances,
Appointed by Calcutta Legal Service Committee. Happiness to it.
My lord, in item number 42, Mr. Kollal Mondal is appearing, my lord. My lord, he is on legs at courtroom number 34, my lord. My lord, kindly passes it over, my lord. My lord, it's a legal aid matter, my lord, kindly. My lord, my lord.
May it please, Your Lordship. Where is that Jittu person? Sit down. My lord, there are three appeals. The first one, my lord, 150 of 2022. Mr. Sundipan Ganguly is leading. And I am appearing in the second appeal. And Mr. Bidut Basu is appearing for the third. Mr. Bidut Basu is appearing for the third appeal. Five convicted, no? My lord, 17 persons were placed on trial. 1 person died. 11 were acquitted. 5 have been convicted. The conviction was under 302 read with 120B and 120B read with 302. Well, I don't know, my lord. But that's the charges were also framed in that same manner. 120B read with 302 and then 302 read with 120B. But kindly comes. But page 6. You have a clear copy. Yes.
তাহলে সেই 13 তারিখের একটা ঘটনা ছিল না, সেই অনুযায়ী কি কনস্পিরেসি এবং তারপর কনস্পিরেসি।
Yeah, but murder could have been charged without 120. Yeah? Yes, it should have been. Should have been 34. But the charges were.
Consider the prosecutor wants to influence person and they were five at the spot. Five at the spot share a common
34.
This act is the product of conspiracy with others and different.
Place the FIR. And that's on page 2, my lord. I, Rishikesh Sharma, hereby submit that today, that is 17th of May 2004, around 7:05 p.m. in the evening, I was on my way to Ghola market, and when I had reached near Benegachi Gram Panchayat office, at that time, I heard a sound of bombing coming from Ghola market area. Instantly, the local people started shouting, "Run away, killing Akhilesh Sharma." I promptly went to Ghola market. As soon as I crossed the Ghola bridge, I saw with the help of torchlight of one passerby, as because load shedding was going on then, that my elder brother Akhilesh Sharma had fallen upon the road at the place where one beam is fixed upon the bridge to protect it and to stop transportation of vehicles through the bridge. And he had gunshot on his head. He was dead and his whole body was covered with blood. On inquiry about my elder brother Akhilesh Sharma, I came to know that he had a cup of tea sitting in the shop of Noren, that's PW6, and before taking tea, he had purchased vegetables in a polythene bag from the shop at Ghola Market. The estimated time may be 7:10 p.m. in the evening. My elder brother had started for home immediately after having tea, and a group of 5 persons had followed him, and one out of those had fired on his head. After that, they had run away by the side of the canal from the furniture shop of Subhash, and he's not been examined. They had thrown a bomb during running away. Sri Amitava Sharma, my son, had taken the body of Akhilesh Sharma to the Baruipur Sub-Divisional Hospital, carrying in an auto rickshaw. The doctor also declared Akhilesh Sharma as deceased. The culprits that have killed my elder brother in cool brain by well-planned manner. The inquest report is on page 4.
Yeah.
Gives a slightly different picture. Says I, Bikash Kumar Nag, Sub-Inspector of Baripur Police Station, today on 17th of May 2004, as per the English calendar, at around 20 to 50 hours in the night, have come at Baraipur Hospital and have started to prepare inquest report of the deceased Akhilesh Sharma at the emergency room in presence of witnesses after identification of the body by them, who have put their signature herein. The deceased body was lying on the back in a dorsal position upon the bed, with the head pointing north and the legs pointing south. The eyes and mouth were half opened, hands were lying straight by the side of the body. Marks of hitting, blowing upon the body have found after turning the body upside down. There are marks of wound upon the right side of the head above the right ear, marks of blooded wound upon left side of the head above left ear, marks of wound which is about 1 inch deep cut on upper portion of left eye and 4 cut marks upon the portion of the left ribs. The wearing apparels of the deceased are cream-colored full-sleeve Punjabi, a white trouser with half vest, white underpant. The deceased body complexion was fair, height medium, and height approximately 5 feet 8 inches. It reveals from the initial investigation that deceased Akhilesh Sharma today on 17/5/2004, as per English calendar, at around 6:30 p.m. in the evening, was returning home after train journey via Ghola Market after stopping there. At that time in the market, while he was passing away by the side of a crowd gathering, one unknown person had fired upon him and he was severely wounded and covered with blood. Instantly, he was brought to Baripur Hospital and the doctor had declared him dead. For finding out the proper reasons of the death with the help of postmortem, the deceased body along with documents is being sent to Mominpur through Sri Bolaya Adhikari, Home Guard, so-and-so. That's witnesses to the inquest were PWs 12, 13, and 14. My lord, the sketch map is on page 6. My lord, we will refer to that later in the course of discussing the evidence. And charge is at page 9 as your lordship has seen. My lord, may I place the witnesses? PW1 is Rishikesh Sharma. I do cultivation. Akhilesh Sharma, since deceased, was my elder brother. He was murdered on 17th of May 2004. The incident occurred at about 7:05 hours at PM. At that point of time, I just came out from my residence to go to Ghola Bazar, which is about 5 minutes walking distance from my house. Suddenly, I heard sound of bomb blast from the side of Ghola Bazar. Then I proceeded towards the bazaar. Suddenly, I found that some people were running away from the bazaar side. I wanted to know about what had happened from the people who were running away, and from them I came to know that my elder brother Akhilesh Sharma was murdered. On hearing the news, I became puzzled. Then I just crossed the bridge and proceeded towards Gola Bazar. I found that my elder brother was lying with profuse bleeding injuries on the road. I also found many people gathered there, including my son Amitava Sharma. Then some people along with my son took my elder brother Akhilesh in an auto rickshaw to Baruipur Hospital, where the doctor examined him and declared brought dead. Subsequently, police came to the spot where I submitted a written complaint to the police. This is the said written complaint, written and signed by me. The written complaint is marked Exhibit 1. At the relevant time of incident, my elder brother was a member of the CPM zonal committee. On the spot, I came to learn that my elder brother was shot dead by some persons when he was returning home from Chittaranjan Hospital via Ghola Bazar. I further heard from the nearby tea stall owner, Naren Hazari, that at the relevant time, my brother, after taking tea from his shop, was proceeding towards his house after marketing. On the next morning, I came to learn that Nauzar Midday, Kashad Ali, Sardar, Rahim Ali Mullah, Yasin Midday, and Yusuf Mir, Najrul Mir, Ayub Ali Sardar had involvement in the matter of murder of my elder brother, Akhilesh. Today, I find the above-named accused persons are present on dock. The witness identified 7 accused persons who are present today on dock. The above-named 7 persons were also supporters of CPM party. Subsequently, I came to learn that my elder brother had protested illegal acts of the above-named persons for which he had been murdered. Cross-examination had been deferred under Section 231. Then, my lord, on the following page, the cross-examination. I do cultivation. I have been residing at my house at village Ghola under police station Baruipur since my birth. I know all the 17 accused persons present today on dock since my childhood, and I know their names. Police came to the PO, Ghola Bazar, about 15-20 minutes after the occurrence from Baruipur police station. Right now, I cannot recollect how long police stayed at the PO, but when they left, I was mentally perplexed. I wrote the written FIR by my own handwriting. I wrote the FIR at Ghola Bazar, and at the time of writing of the FIR, besides myself, none was present there. After sending the dead body of my brother Akhilesh Sharma to hospital by auto rickshaw, I came to my residence, and sometime after I was called by police at Ghola Bazar, and there I wrote the FIR. On hearing the sound of bomb, I proceeded towards Ghola Bazar and found the dead body of my brother was lying there. But during that time, I did not find my nephew Anirvan Sharma there. But my son Amitava was present there, but I had no talk with him. I had also no talk with the people gathered there. When I went to Ghola Bazar at the call of the police and wrote the FIR, I found some villagers present, but I had no talk with them.
The main witnesses will be 3, 4, 7, 8, and 11.
What is the, yes, my lord, 3, 4, 7, 8, 11.
3, 4, 7, 8, 11. 6 tea stall owner res geste.
Yes.
Res geste. Others seeing them run away. So far as House Kasad, we find PW4 is only naming Kasad. Nobody else has named Kasad. Please give us a chart as to who are the persons who are naming, in addition to the other arguments. Ayub, PW3 names Robi, Rohim and Nausar.
As having fallen down. As having fallen down while they were running away.
Yes, Rohim and Nausar. And then 4 is Rohim, Kaser, Yasin, Yaub. 5 heard, 6 heard about the incident, people saying Nausar, Yasin, Rohim and Ayub have killed. 7 sees Nausad, Yasin, Rahim. 8 Rohim, Yusuf, Ismail. And 11 who was accompanying the deceased speaks of Yasim, Rahim and Nazrul. Is Nazrul Nausar? That is another clarification we want. So these are the things. Apart from the fact whether at all these witnesses are reliable, inherently improbable version. If broadly the witnesses are believable, having seen the person moving out of the tea stall of PW7 along with PW11, PW11 proceeding a bit further, the deceased following him, hears gunshot, turns around, number of people running away, they are being identified by some of the witnesses. This is the prosecution case.
Except
fact that he died due to gunshot injury proved by PW18. That's the PM doctor. So,
an important
on this structure,
huh?
But they're running away. That is recovery made from any one of you? No recovery is made. So this is the case.
An important point, my lord, which will arise later in the arguments is the investigating officer admits that until 21st of May, no name, he could not gather any names.
All right. How long, when the incident occurred?
17th.
17th. The witnesses were examined within 3-4 days.
My lord, the point is, my lord, the investigating officer was in the village. No one had told him. These people there.
161 statements are there. The statements before the police are there. You have not cross-examined him when these witnesses were examined.
No, my lord, cross-examination has gone on. What has happened is, my lord,
Mr. Dasud, then you have to cross-examine that in their earlier statement, they did not say that they had seen XYZ running away.
No, my lord, point is, my lord, the first investigating officer demitted office on 1st of July. I mean, he was transferred. My lord, the second officer who did the bulk of the investigation, and we could never cross-examine.
What investigation? Only 5 people eyewitness seeing running away. That is the investigation.
No.
Apart from maybe collecting blood from the spot, sending for forensic,
that also never
PM record, that also has not been done. Now, the other aspect of the matter is prior to the incident, earlier date, there was a
meeting,
a sort of
meeting,
an altercation between Nosad and this deceased in the shop of PW6.
Just outside the
shop. Outside the shop of PW6. So, that is it. Yes. What we want is, on the next day, we want a written note about the synopsis of the evidence and your arguments so that you can begin your arguments. We have gone through the evidence. Now you make your arguments.
Want to hear them today, my lord, or on the...
No, we want that note before us so that, Mr. Dastur, we can collapse the hearing to specific points that you raised. We have gone through the evidence, more or less evidence. So now you, in your argument, just indicate the line where you want to, when you make your argument. All right. after we returned on 18th of February.
On
8/1/8/18.
18th of
Or we will keep it এই শোনো এইটাকে ওইখানে সেকেন্ড ডেতে রাখো তো ওই কি আছে দেখো we'll give you 1 week advance, maybe 10th or 11th of February. 10th or 11th of February.
ঠিক আছে
Further hearing রাখো 10th এ কোনটা আছে এইটা নামটা কি we keep it. There's one after that because you will take some time. We will hear you again and then keep it in mind. What we want, Mr. Dastu, we have followed the basic. We've gone through very cursorily the evidence, the identification of the witnesses, how the prosecution case pans out. Now, what we want is more particularization. Prepare a note on the short synopsis of the evidence as well as the areas where you want to show the improbability of the case. The way you say that if Animesh had come to the spot, PW1 came to the spot, all the people had seen running away. Now, whether this is finding place in the FIR. Right. Secondly, the delayed examination or disclosure of the names. So these points you just indicate to us. Okay. Call combined list.
combined list.
Miss A, do your chart and prepare your notes.
And matters treated as heard part.
No, further hearing, we're keeping it as further. Mr. A for whom?
I'm assisting Mr. Datta.
Mr. Datta. You are assisting Mr. Ganguly. So why are you so far away from Mr. Datta? Interspersed with Mr. Ganguly's juniors? Now you come to North Bengal. $235, 230 monthly list. They are saying they are going to some Shintai or something. They got orange color. Monthly list. Monthly list.
Item 265, my lord, kindly fix it. My lord, kindly fix a date, my lord. Item
265, what is there?
My lord, my lord, the applicant is languishing in custody for 6.5 years, my lord. Kindly fix any date, my lord.
What is the conviction?
My lord, 302.
302. 265. Supplementary list on 5th.
Much.
To be mentioned দিয়ে দিন to be mentioned দাও বা ওখানে দাও for hearing করে দাও তারপর দেখো or monthly list of February. Same. He cannot read English. Same. Same.
41 lots.
Monthly list of February. First, let us do your that other matter. Then lots. Give your name if you want. Give your name. Your name will be entered. 81. Same. 404. Same. After your name will be entered on the prayer of the appellant. যেখানে নাম আসছে না সেখানে on prayer of the appellant monthly list. 205 to 423. 400. Where is 457? Yes, Mr.
30.
Yes, sir.
There is a CRAN application for suspension.
1 second, 1 second. 4 up to 425 from 405.
Previously, you also asked me to mention for application because
1 second, which one you want? 430 is within 425.
No, sorry. I thought, no, combine me. Fine. I'm sorry.
Monthly list of February. लड़की भी एक रिजल्ट लगा है 1 पैसा नहीं देता है उसको उफ ना 57 ना रे भाई up to 4 430 will 1 second will come up tomorrow under bail in connection with it.
Yeah.
No day after tomorrow. Tomorrow we'll dismiss it.
Out of 10 years, he has already under 80 years.
Again, immoral trafficking.
So there is absolutely nothing against.
No, now no case anything is against. No case anything is against you. All judges are biased. All investigating officers are corrupt. All right, on the 5th of please. Zarin, please see who is there in 430. where a public prosecutor is top.
Sanjay Banerjee.
Oh, you appear. Please tell Mr. Rai.
He will.
What Sanjay Banerjee?
He will come.
He may come, but he will never be prepared. Then you ask Sanjana to be prepared. Someone, you appear to be ready. Sanjay Banerjee ornament. Please. All right. Other matters tomorrow.
One matter, I missed it, 219 and 218, this is a death reference. Again, this lady, I found all offences committed in Hyderabad. No offense in West Bengal. Still, charge claim that Hyderabad.
Did the death reference come up there?
Travesty of justice, can you see?
All travesties of justice. Listen, please read 462 Code of Criminal Procedure and then come. Territorial jurisdiction is no ground to set aside conviction. All.